Welcome back, sir. Let us start with the next chapter in the Indian Contract Act. Previous exam question papers. है ना? Chapter number 9, discharge of a contract. है ना बेटा? So first question was asked in November 2018 for how many marks, sir? 4 marks. See, for 4 marks, this much lengthy question is there, beta. So actually, we have discussed this question in the first chapter also. So XY entered into contract on 1st August 2018. When contract was entered, beta, on 1st August 2018, X and Y entered into contract on 1st August 2018. X has to pay 50 tons of the sugar to Y. X has to pay 50 tons of sugar to Y at a certain price strictly within 10 days of the contract. That is, on before 10/8/18, X has to pay the X has delivered 10 tons of the sugar. Happy. Y also paid amount of 50,000 rupees as advance as per terms of the above contract. Y paid advance also, beta. So Y paid 50,000 rupees to X also. Advance. Happy. The mode of transportation available between the places only roadway between X city and Y city. Severe floods came on 2nd August 18. When beta? On 2nd August 18, there was a heavy rain and floods. And the only road connecting the places was damaged and could not be repaired within the 15 days. This road could not be repaired till the 15/8/2018. Happy. X offered to supply the sugar on the 20th August. So X said, I cannot come to your city because there was no road. I will supply the sugar on 28/18. But Y said, I want it before the 10th only. X offered to supply sugar on 20th August, for which Y did not agree. Y said, no. I want sugar. I don't want sugar on the 20th August. I want it only before the 10th only. That is a Y argument. Did not agree. On 1st September 18, X claimed compensation of 10,000 rupees from the Y for refusing to accept the supply of the sugar. So on 1st September 18, X sued Y for 10,000 rupees from Y. Can he, beta? No. Because how can he claim the money from the Y, beta? He cannot. And on the other hand, Y claimed refund of 50,000 rupees which he has paid in advance in terms of the contract. So Y is demanding. Y said, I want back my 50,000 rupees. Y said to X, I want back my 50,000 rupees advance. Can Y demand from X, beta? Yes or no, sir? Yes. Unless the above situation in terms of the provisions of the Indian Contract Act, Y's contention is right or not? Y's contention is right. Y can demand back the 50,000 rupees advance from the X because it is supervening impossibility. Which impossibility, beta? Subsequent impossibility, supervening impossibility, or void contracts. Provision of the law. Subsequent or supervening impossibility or becomes impossible after entering into contract. When performance of the promise becomes impossible or illegal by occurrence of any unexpected event or change of the circumstances beyond the contemplation of the parties, the contract becomes void. It becomes a void contract. Also, as per section 65 of the Indian Contract Act 1872, when an agreement is discovered to be void, when the contract becomes void, any person who has received any advantage under the agreement or contract must restore it, restitution, and to make the compensation for it to the person from whom he has received. Here, X was received the advance from the Y, so X has refund advance to Y. Facts of the case. In the given question, after X and Y have entered into contract for supply of 50 tons of the sugar, the event of flood occurred which made it impossible to deliver the sugar. So contract becomes void. So contract becomes what beta? Void. Decision. Thus the promise in the question becomes void. Further, X has to pay back the amount of 50,000 rupees that he has received from the Y as an advance for supply of the sugar within the stipulated time. Hence, contention of Y is perfectly correct. He can get back his 50,000 rupees. And second question beta, second, third, fourth, 2002, 2011, 2013, same question came beta. State the grounds upon which a contract may be discharged under the provisions of Indian Contract Act. Same question. In how many methods a contract can be discharged? Broadly, 1, 2, 3, 4, 5. One by one. First, by performance. Again, it is two types beta. First one is actual performance. Second one is the attempted performance. Attempted performance. In these both the ways, contract may be discharged. Second one by discharge by mutual agreement. It is of the 5 types beta. Novation, alteration, rescission, remission, waiver. Next, third method by operation of law. It is 4 types again. Death of the offerer or the offeree, and insolvency of the offerer or the offeree. Next one, unauthorized material alteration. If you observe in the regular class, I gave big chart in one page itself. Unauthorized material alteration. And last one is the identity of the promiser. That is, promiser becomes the promisee. I gave a bills of exchange example. I gave the promise note example. And next one is this one is very important beta. This question is very important among all. D1 is very important. Discharge by impossibility, that may be destruction of subject matter or personal incapacity, declaration of the war, change of law, and among these 5, this one is important. Non-existence of, non-occurrence of state of things required for the performance of a contract. Because in a one king case law also here, if you observe, if you remember, exceptions in the following cases, contract will not be discharged on the supervening impossibility. Exceptions also important beta. Fifth heading is totally important. First one is difficulty in performance. Second one is commercial impossibility. Third one is default by third party. Next one is strikes, lockout, civil disturbances. Last one is the partial impossibility. In these 5 cases, contract will not be discharged based on supervening impossibility. Next, discharge by lapse of time, that is as per Indian Limitation Act. As per Indian Limitation Act. Last one is discharge by breach of contract. It is 2 types again, actual breach and anticipatory breach. Anticipatory breach. So these are the various methods to discharge the contract. So directly we can write beta heading and subheadings. If you want, you can explain each subheading with one line based on number of marks. Next question beta, 5th to 6th. Explain the circumstances under a party to a contract may be exempted and exceptions from the performance of a contract on the grounds of supervening impossibility. He is asking this question beta. Exceptions to supervening impossibility. Exceptions to supervening impossibility. Beta. I said no already. This question was asked twice. 2006, 2014. So, when contract will not be discharged based on supervening impossibility. Supervening impossibility, a doctrine of frustration, another name, means impossibility which does not exist at the time of making of the contract, at the time of making perfect, but which arises subsequently after formation of the contract. After formation of the contract, it was found that something is missing. It is said to be supervening impossibility. Which impossibility beta? Supervening impossibility. Is asking the examples and exceptions. First one is the destruction of the subject matter. Car is destroyed, contract is discharged. Death or personal incapacity. So after become deceased or mar gaya, contract is discharged. Declaration of the war, Party become alien enemy, contract will be discharged, change of the law. So sale of the wine become illegal, wine business है ना बेटा. मोड अंकल said आज रात 12 बजे से दारू पीना बंद. So business become unlawful. Last one, non-existence or non-occurrence of the state of things required. We have seen the king example, king case law. Because of the illness of the king, the coronation process was cancelled है ना बेटा. So contract will also cancelled to view that large example. And exceptions beta, in the following exceptional cases contracts will not be discharged, will not be discharged based on supervening impossibility, based on the subsequent impossibility or supervening impossibility. And the first one, difficulty in performance is different, impossibility is different beta. Our heading is impossibility, difficulty is different, impossibility is different. I gave the CA ranker example. Next, commercial impossibility, I gave the bench example beta, making of the bench. Next, default by third party, default by whom beta, third party, contract will not be discharged. Next one is strikes, lockouts and civil disturbances है ना. I got the fan example, colorful fan example. Last one is partial impossibility. Here also I gave the king example, king case we have seen boat example beta, contract will not be discharged है ना, based on the supervening impossibility. Next, last question in this chapter was asked 3 times. If you're observing beta, the same question is being repeated so many times from the first chapter also. I am telling you beta, the same questions will come again and again and again and again. This question is came in 2004, 2005 and 2007. So Achilles entered into agreement with the Shaker to deliver him 5,000 bags of the 5,000 bags to be manufactured in his factory. The bags could not be manufactured because of the strikes. See, exception is the strikes, lockouts, civil disturbances. Contract will not be discharged. Contract will not be discharged. Answer आ गया. Strikes by workers. Achilles fails to supply the said bags to Shaker. Decide whether Achilles can be exempted from his liability. No, you have to supply है ना बेटा. So Achilles was there beta. Achilles has to supply rice to whom beta? Shaker. Subsequently Achilles said, my dear buyer, there was a strike in the factory, labor is not coming, so I cannot supply rice. Can he say like that beta? That is your headache. So whether strike is there, he has talked to his employees, that is Achilles headache. Contract is not discharged. Contract is not discharged. Even there was a strike, Achilles has to supply rice to Shaker, otherwise he has to compensate the Shaker. So same question. In the contract, let us see the answer also once beta. Supervening impossibility means impossibility which does not exist at the time of making of the contract, but which arises subsequent to after entering the contract. This will happen in the following ways. Destruction of subject matter, car is destroyed, and death or personal incapacity, declaration of war, change of law, non-existence or non-occurrence of the state of things required. But exceptions. In the following exceptional cases, contract will not be discharged. Example, difficult in performance, commercial impossibility, default by third party, strikes, lockout, civil disturbances, and partial impossibility. In the following cases, contract will not be discharged. So Achilles entered into agreement with Shaker to deliver him 500 bags of the 500 bags to be manufactured in his factory. The bags could not be manufactured due to strike by the workers. Achilles failed to supply the said bags to Shaker. Contract will not be discharged based on supervening impossibility. You have to compensate the buyer. The same question was asked again and again 2005 and 7 also. M contracts with the Shanti traders to make and lend and deliver certain machinery to them by 36 2014. We'll discuss this shop. This question will come again in the next chapter beta. Ramaswamy Chennai placed an order with Shah of Ahmad for supply of the Urud dal 10, 11, 16 at a contract price of 40. These two questions we will discuss in the next chapter beta. Actually, these questions will come again. In the next chapter I have covered that questions, I think. That also supreming impossibility only. M limited है ना बेटा, M limited contracts. This question we will discuss again, and Ramaswamy question also. Let us see. These two are same questions beta. We will discuss these two questions in the next chapter है ना. Have a great time, enjoy the day, prepare well. SG signing off.